Hearing in the Queen on application of Mott against Environment Agency.
Yes, Mr. Lewis.
My Lords, I appear with Mr. Lewis for the Environment Agency, the appellant, and Mr. Hockman and Mr. Beard appear for the respondent, Mr. Mott. Can I begin by handing up some additional documents that will come to in due course?
Oh, dear.
It's a terrible start, I know.
What an awful start.
Terrible start,
Yeah.
I know. But if I could just explain what they are. There was an extract from Emerson and Seymour on human rights practice, which was missed from the authorities bundle. One additional authority, and then we've also put in a couple of plans just to show the location of the fishery we're talking about, because there's none of those in the bundles. And there's
Yes,
also,
I'd wondered about that.
Yes.
Just wanted to know where it was.
Well, I hope if you look the third document of those that you've been handed up, you should have two plans which seek to put the fishery in its geographical context. I will come to it in a bit later on. And we've also put in 3 photographs to show the rank, butcher rank that we're talking about. Because there was a photograph in the bundle, but certainly in my version it was almost impossible to see anything in the photograph.
Thank you.
My Lady, my Lords, the issue raised by this appeal, we say, is when compensation must be paid to avoid a breach of Article 1, Protocol 1, in circumstances where the interference in question is imposed in order to protect the environment and avoid environmental damage. Now, the issue, we say, arises in this context. The Environment Agency, in the exercise of powers conferred on it by paragraph 14A of Schedule 2 of the Salmon and Freshwater Fisheries Act 1975, as amended, imposed a catch limit or catch limit conditions on Mr. Mott's annual fishing licences for the years 2012, 2013 and 2014, limiting the number of fish he could catch in his butcher rank to 30, 23 and 24 respectively. And the agency did so because following assessments that it undertook and relying on expert evidence, it concluded that those catch limits were necessary for fishery protection reasons and in order to protect important environmental interests. Now, in particular, and I'll come to the detail a bit later on, but in particular, the concern that motivated the agency's decisions was a concern about salmon stocks in the River Wye. And the River Wye is designated, as you will have seen, as a special area of conservation under the EU Habitats Directive, as indeed is the Severn Estuary itself, where Mr. Mott's butcher rank is located. And these European sites, as the court will know, thus benefit from the very strong protections conferred by the EU Habitats Directive and the transposing regulations on such sites. Now, moreover, in terms of the context, one of the main reasons for designation of the River Wye SAC was the need to conserve salmon stocks. And at the time of the decisions that we're concerned with, the Welsh Government's advisor on conservation issues, so initially the Countryside Council for Wales, later Natural Resources Wales, advised that the salmon stock in the River Wye was in unfavourable condition and at risk. And crucially, the salmon which Mr. Mott catches in the estuary, the Severn Estuary, the agency say, on the basis of expert evidence, comes from what's called a mixed stock fishery. That is to say, the population of salmon within the estuary is destined to return to several rivers, including the Wye. And as you will have seen, before issuing each of the 3 licences with the catch limit conditions that are in issue in these proceedings, the agency undertook habitats regulation assessments as required by the Habitats Directive and the transposing regulations. And the catch limits that were imposed via the conditions were adjudged by the agency to be necessary in order to avoid any adverse effect on the integrity of the European sites. And I'll come to this in a moment, but these assessments were agreed with by Countryside Council for Wales, later Natural Resources Wales. Now, my lady and my lords, in the courts below, as you will have seen, Mr. Mott challenged the rationality of those assessments, alleging that the expert evidence upon which the agency relied was fundamentally flawed. The Court of Appeal overturned the decision of the judge at first instance on these matters and determined that there was a rational basis for the agency's decision-making in this regard. And there is, as you know, no respondent's notice on that point. And so we do say the starting point for this appeal must be that the licences in issue and the conditions contained in them were lawfully and properly imposed under the 1975 Act and imposed in accordance with the requirements of the relevant habitats legislation, that they were rational, that is, based on expert evidence which the agency was entitled to rely to reach the conclusions they did. And I only raise that, my lady, because in places in Mr. Mott's written cases, in my submission, there is a lapse into challenging the evidence underlying these assessments, which is not the subject of this appeal. The issue instead, very simply, is whether the decision, which in all other regards is lawful, proper and appropriate, is unlawful under Article 1, Protocol 1, absent the payment of compensation.
But that's very frequently the case. Where human rights are involved, it's very frequently the case that what a public authority has done is perfectly rational and lawful, but the question is whether it's compatible with the Convention rights. My lady, I accept that, and I only make the point because, as I say, there are places in my learned friend's case where there's a lapse into seeking to question the validity of the underlying evidence that inform the assessments. The issue is, we say, much more limited than that because, on the basis of the appeal that was made. Now, in terms of I'm
yes. Should have perhaps picked it up. Where the power to pay compensation, assuming it's required under comply, where does that come from?
There isn't a power to pay compensation in relation to the conditions that we're concerned with under Section 25. There is no power at all. I'll touch on this later on. You will have seen that in the history.
I'll come to it later if necessary. I mean, it seems it may be rather important.
There is certainly no power, and I will come to the legislative scheme in due course.
But it's accepted that you can do it, if only ex gratia.
The way, yes, ex gratia, and indeed the agency has a general power similar to the one that you'll be familiar with from the Local Government Act 1972, Section 111, to do anything that's incidental or to powers and functions. So
it's not a case where we have to worry about declarations of incompatibility.
That's never been the way the case has been
Thank you.
on either side. And indeed, my Lord, you will have seen that in the past, and I'll come to this when I deal with the facts in a moment, but in the past there were payments made by the agency to Mr. Mott not to fish in certain years. So there is no question that there's a generic, no specific power.
So, I mean, quite apart from the Human Rights Act, it would be open to the agency to say, as a matter of discretion, we think this has such an unfair effect on this particular person that we should make some compensation payment.
Well, there certainly is we certainly got the power. I will show you in the legislative scheme. There is obviously a position under legislative scheme where Section 25 that we're concerned with, which allows the imposition of catch limits, doesn't expressly refer to compensation. The very next provision, which deals with something else, net limit orders, does expressly empower compensation. Yeah. Those are not applicable here, but the way the case has been argued to date, and the way it's put is, it's not suggested that there's any need to sort of talk about implied powers as such. The issue here is, does Article 1, Protocol 1 require compensation to be paid in order for this interference?
I mean, I just think there might be a sort of narrow issue, which is, does it require the relevant agency to consider whether this is a case for compensation? And a failure to do so might be a breach. So as I understand it, you've always taken the view that simply as a matter of principle, you're not going to pay compensation.
Correct, we're not going to pay compensation
Anyway,
you haven't always taken that view.
No.
No, although obviously a number of the times we paid Mr. Mott not to fish was at a time when we weren't able to use.
You hadn't got the power to
impose conditions. That's not true for the final. It's not true for the final payment. I accept that.
Anyway, when we come to look at the case law, we might have that in mind as a possible fallback.
So in terms of the structure of my submissions, what I intend to do is I'm going to deal as briefly as I can with the factual background. I'm then going to turn to the legislative context, in particular the 1975 Act and the Habitats regulations. I'm then going to look very briefly at the judgment of the Court of Appeal on this issue, the Article 1, Protocol 1 issue, before turning to make my main submissions on Article 1, Protocol 1. And I'm going to do that under two heads when we get to it. One is I'm going to set out a number of propositions of what I say are the relevant legal principles by reference to the case law. And then I'm going to make what I hope by the time I get to it will be relatively brief submissions about what are the three agreed issues on this appeal. And the three agreed issues are set out in the Statement of Facts and Issues at paragraph 51. Effectively, the three issues are whether the conditions are a control of use or a deprivation. Secondly, if they're a control of use, was there a requirement for compensation? And thirdly, in the alternative, if it was a deprivation, is this an exceptional case to avoid the payment of compensation? And obviously, it's critical to our case that we say this is a control of use and not a deprivation de facto or de jure. And we say that is critical because, as you'll know under the case law, the general rule or presumption is no requirement for compensation for a control of use.
Well, we're going to get into that later.
We are.
In fact, that is the main issue that we're interested in.
That is the key issue.
And whether, in fact, there is such a sharp distinction between expropriation and control of use, as is suggested by what you've just said. But we'll come to that.
Come to that. Can I then deal with the facts briefly? I'm going to do it by reference to two documents. One is the Statement of Facts and Issues, and the other is the Court of Appeal's judgment. They're both in Core Bundle 1. The Statement of Facts and Issues begins at Electronic Bundle, page 25, and the Court of Appeal's judgment is at Electronic Bundle 118. And I'll turn to both those documents as we go through the facts briefly.
Oh, I'm terribly sorry. Your numbering is one out.
One out, okay.
It's only one out, so we can
Only one out,
we can live with
I'll
it.
try and bear that in mind. So the Statement of Facts and Issues starts on EB 26, does it, on your?
It does, yes.
Okay, I'll try and bear that in mind as I go.
Don't worry.
So in terms of Mr. Mott's interest, Mr. Mott's leasehold interest and his operation of the Butcher rank is covered in the Statement of Facts and Issues at pages 1 to 3, and that'll be Electronic Bundle 26 to 28. The key things are, without reading it, he has a leasehold interest in a Butcher rank. And as you'll have seen, this is a traditional form of fishing predating the controls on salmon fishing introduced in the Salmon Fisheries Acts of 1861 and 1865, and hence these are commonly referred to as either privileged engines or historic installations. And his leasehold interest is for 2 stop nets and 650 butchers, and those latter is what we're interested in. And that lease was entered into in 1998 and expires in 2018. The terms of the lease are summarised in paragraphs 5 and 6 of the Statement of Fact and Grounds, which is Electronic Bundle, pages 26 and 27, pages 1 and 2 in the hard copy. And Mr. Mott, if one looks at paragraph 12, Mr. Mott, in fact, operated this rank going back to 1975, and his evidence is that he earned his living from this until 2011, and his evidence is he had an average catch of 600 salmon per year.
This is a pure lease of a fishing right, as I understand it.
Yes,
it's not a lease of any of the land or the equipment or anything like that.
The lease does cover the right to store the nets on the land beside the butcher rank itself, and it also gives a right of access to get to the butcher rank. But the essential right, your Lordship is correct, the essential right is a lease over the rank itself in the river rather than...
The rank is a physical structure, though, isn't
Yes.
it? I mean, we can see it
In the photographs we can see. So the rank is a physical, you can see it's a physical...
So he's got a leasehold interest in that physical structure,
rank, yeah.
as well as the right to use it.
Yes, that's...
Is that physical structure property or chattel? I mean, it may not matter.
Is it property? Well, I mean, I think we've always accepted is a proprietary interest. We've always
Yes,
accepted
real property, I should have said.
well,
A fixture.
That's what I was going to ask too.
And I also as a follow-up, is it covered by the 54 Business Tenancies Act?
my lord, I'm not going to hazard a guess at those answers to those questions. I will look at that if.
I mean, it shouldn't matter, and it may not matter, but one of the things we look at when we come to the cases is there seems a sort of distinction between a real property interest and things which aren't, and you may need to look at that.
A lease which covers a lease which extends to fishing rights, in my submission, is obviously a possession for the purposes of Article 1, Protocol 1, and indeed the Posti case, which I want to look at later, that was one of the Greek fishing cases, holds a leasehold interest that effectively confers fishing rights to be a possession, so there is no issue about that in terms of Article.
Does it matter that it's going to end in 2018 next year, or should we assume that it would have been renewable?
I don't think we've ever sought to suggest that it necessarily would have ended in 2080. Obviously, it pre-existed the current lease. I'm not sure that's necessarily something that we've ever sought to argue. And indeed, of course, one of the points is that these conditions that we impose are an annual restriction. They're not for all time. And each year, the view is taken on how many fish can be caught. And of course, if the stock recovers in the longer term, which is the aim, then by definition, more fishing.
Do you have an electronic bundle number for the lease itself?
For the lease itself, my lord, I do, yes. It's
Adding one page.
check, yes, it's page 347 if you add one page, EB 347 if you add one page. You'll see that it actually grants and demises the right to fish on the putchers, and then it also gives a right to store equipment ancillary to that on the land nearby, and also a right of way to access it.
It looks as if it's simply the right to fish 2 stop nets and 650 putchers, but not a lease of that equipment or a lease of anything other. It's a pure fishing right, as you say, plus a right to store and a right of access.
My lord, that does appear to fit with what the words say, yes.
Yeah. So it looks as if what we see in the photographs is something that he has to provide himself. Equipment.
The nets,
that's the structure that stretches out across the river.
Well, not the structure, I don't
Well,
think the structure's... Well, the nets he certainly does.
If I can help in briefest terms, the answer is yes. All the equipment has been provided by Mott themselves.
Including the butchers?
Yeah.
Right.
Absolutely.
Yeah.
Yeah. Yes.
So that's Mr. Mott's interest. In the Statement of Facts and Issues, electronic bundle 27, page 2 in the hard copy, there's a section on the need for a fishing licence, and I'll come to this when I deal with the legislation, but you'll have seen that there was a requirement under the 75 Act for there to be a licence granted each year to allow for salmon fishing in the Severn estuary using the butcher ranks. And until 2011, for an historic installation, such as we're concerned with, there was no power to impose catch limits. And that was only introduced in 2011 through the Marine and Coastal Access Act 2009. I'll come to the legislation in a moment. And then next, in terms of the background, an important part of the background is the Environment Agency's view based on expert evidence, including the so-called Exeter report, that the Severn estuary is a mixed stock fishery. Can I ask you to go in the Statement of Facts and Issues to paragraph 16, it's electronic bundle 29, page 4 in the hard copy, and you'll see paragraph 16 says the agency's case throughout these proceedings has been that all of the fisheries within the Severn estuary exploit a mixed salmon stock with components destined to return to a number of rivers, including the Wye, before the power to impose catch conditions on historic installations came into force, there were two main studies which the agency asserts had concluded the Severn Estuary exploited a mixed salmon stock, and they're the Swain study and the Jones study, and later that was added to by the so-called Exeter report. And can I ask you then to take this up in the Court of Appeal's judgment? So that's still in Core Bundle 1 at Appendix C. It starts at page 3 of the hard copy, Electronic Bundle 119. And in particular, can I ask you to go in the judgment, please, to paragraph 18, which is Electronic Bundle 124, page 8 in the hard copy. And in the judgment of Lord Justice Beatson at paragraph 18, he refers to the Habitats Directive as providing some of the background, and then talks about the background also including national policies influenced by international organisations, and then refers to the two studies that we've just seen. And then in paragraph 19, he explains that the account that is about to be given comes from a document called the Technical Case for Two Net Limitation Orders for the Severn Estuary. That's a document you do have in the core bundle. I don't ask you to go to it now, but you do have that in the core bundle. It's in Appendix F9 in core bundle 2, hard copy page 294, electronic bundle 410. I don't ask you to go to that now. And then paragraph 21 of the judgment on the same page, you'll see there's a heading National and International Policies. It says the regulatory background includes government policies from 1996. So I ask you to note that's prior to the most recent lease, and the lease that Mr. Mott currently operates under. But government policies from 1996 to phase out fisheries which exploit predominantly mixed stocks. And then it carries on 4 lines down. It's stated in paragraph 1.23 of the technical case document. The policy was adopted in 1996 in England and Wales, and in 2001 the English and Welsh governments accepted advice of the Salmon and Freshwater Fisheries Review that mixed stock fisheries should be phased out wherever possible. And the United Kingdom had previously identified 3 such fisheries in England, one of which was the Severn Estuary, and the position was reaffirmed by the agency in a 2008 strategy. And it says it will move to close net fisheries that exploit predominantly mixed stocks where our capacity to manage individual stocks is compromised. And then 22, the background also involves consistent advice from the North Atlantic Conservation Organisation to national regulators, such as the agency, to control the exploitation of salmon where river stocks do not exceed their conservation limits, and in 2013 to prevent exploitation in such cases. That document stated earlier that the Countryside Council for Wales concluded the River Wye salmon feature is in unfavourable status, and that while the position of the Severn Estuary European Marine Site has not been specifically assessed, its status draws on that of the rivers contributing salmon to the mixed stock within the estuary and is also deemed to be unfavourable. And then there's a reference, you'll see the Exeter reports, which I'm not going to go through in any detail, start paragraph 23. The Court of Appeal summarises the effect of the Exeter reports. And you'll know the Exeter reports were the most recent report which the agency relied on to show that this was a mixed stock fishery, predominantly mixed stock fishery. In terms of the background, can I ask you then to just go back to the statement of facts and issues to deal with a topic we did touch on a moment ago, which is the position up to 2011. So it's paragraphs 20 to 25 of the statement of facts and issues, page 5 of the hard copy, EB 30 on the electronic bundle. And again, I won't read this, but the position on which the facts are not disputed is that payments were made by the agency in 2004, 2010 and 2011 to Mr. Mott not to use his butcher ranks. And the last of those that we accept post-dated the coming into force of the power to impose a catch limit condition. And those facts are not in dispute. The respondent's case relies on those payments of compensation under the Article 1, Protocol 1 issue. We do say that in terms of the legal issue, there is no relevance to the fact that we have paid compensation in the past. The issue is whether we're required to do that under Article 1. Protocol.
Why did you pay compensation?
Well, can I give 2 answers to that? I mean, well, first of all, we were paying at that time for the first two payments, certainly, at a time when we had no power to impose them.
No, but
And then, secondly, beyond that, and I say this may be relevant to the fair balance, the agency did attempt, and has attempted, as is recorded here, to try and deal with this through agreement rather than by using powers. We tried to purchase the rank. That failed. And those payments of compensation for him not to fish in certain years also have to be read in the context of us seeking to try and do this by agreement, which we did try to do, but unfortunately agreement wasn't reached. So that's the context in which we paid that compensation. It was part of a process by the agency of trying to deal with this through negotiation rather than by using our powers.
But your current case is that you are under no legal obligation to pay any compensation.
Correct. Correct. My Lord, I accept that, but my Lord, in terms of, obviously the question that ultimately faces this court is whether in exercising the powers that we did, is a fair balance struck absent compensation. Now, in my submission, the fact that we have attempted to, in the past, deal with this by agreement, is a fact relevant to whether the fair balance has been struck. We have tried to deal with this through agreement. It didn't work.
Well, it's a factor that fits both ways, doesn't
Well,
it?
that's...
You're relying on it to say, well, we tried, we were being very, very reasonable. We did our best to sort it all out by agreement. And he'll be saying, but yes, the fact that you tried to buy me off raised an expectation in me that I was entitled to something by way of compensation.
Well, my Lady, I accept it's a point that can work both ways. I'm not sure it's put quite as strongly as it gave rise to an expectation, but my Lady, I'll accept the basic point that it's a point that can go either way. I'm not going to seek to dispute that. We do say though...
Does fair balance come into it at all if this is not expropriation?
Well, no, the fair balance test would still be applicable it's still applicable to a control of use. I mean, it's put in slightly different language by the European Court, but it's still, even a control of use has to be tested about whether it's in the general interest and strikes a fair balance. And there are examples of controls of use that have been found not to strike a fair balance, despite being merely controls of use. But what we do say is, we say that this compensation that was paid and attempts to reach agreement in the past are not decisive of the legal issue which we now have to determine, has to be determined. In terms of the background, just to move on, if you look back on page 4, so that will be electronic bundle, page 29, the relevant facts in relation to the Habitats Directive are recorded in paragraph 17 to 19. And I've really touched on these already. You'll see in paragraph 17 the River Wye designated a SAC, a special area of conservation. 18, one of the main reasons is the conservation of salmon stocks. Then in the same paragraph, reference to the Severn Estuary itself also being a SAC, an SPA and a Ramsar site. And that together these areas also constitute the Severn Estuary European Marine Site, for which salmon is a qualifying feature. And then 19, we've seen this before in the Court of Appeal's judgment, the relevant nature conservation bodies have assessed the status of salmon in the Wye in particular as unfavourable and at risk, and said the conservation objectives under the Habitats Directive are not being met. And similarly, the stocks in the Severn are probably at risk and declining. And I should say the first plan that you've got, which we handed in this morning, does show marked on there some of these designations that we're talking about. So the purple colouring shows the SAC designation, which you'll see extends up the estuary and includes the location of the Putcher rank, but also the two rivers, the mouths of which you can see entering the estuary, the Wye and the Usk, are also coloured purple because they themselves are SACs. Some of the other designations are also shown on here. The SPA and the Ramsar side are also shown on there. So in terms of the events then, if I can, leading to the imposition of the catch limits, again, we can take this from the Statement of Facts and Issues. If I could ask you to go to page 6 in the hard copy, electronic bundle, page 31. There's a heading, the 2012 to 2014 seasons, and you'll see paragraph 30 as a letter written by the agency informed the respondent of the Exeter report and said it provides clear evidence of the mixed stock nature of the catch in the Severn Estuary And there's an explanation there of the Exeter report as a genetic analysis of DNA samples collected by the agency from fins or scales of fish in various tributaries of the Severn, and its stated genetic markers for salmon could be used to assign a fish to a particular river. And then 31, you'll see drawing on the Exeter report, a HRA, so that's a Habitats Regulation Assessment, which I'll come to in a moment, dated the 24th of May 2012, concluded that recent and future potential unconstrained catches of salmon in the estuary threaten the integrity of the River Wysack, which is judged to be at risk for failing to achieve its annual conservation limit and its 5-year management target. And then it determined over the page the permitted catch for historic installations, including for putcher ranks, by reference the lowest catch of any of the historic installation fisheries that had sought a licence in the preceding 10 years, and this led to the catch limitation of 30. And then you'll see in 2013 there was a similar assessment, but that method would have resulted in a permitted catch of 15, and the agency considered that too low, and so instead imposed 23, again on the basis that this was the approximate long-term de minimis catch, i.e. the lowest catch that was being licensed within the area. And then 33, you'll see the 2014 Habitats Regulation Assessment is referred to. They're all in pretty similar terms. And 34, none of the HRAs explicitly recorded that the agency had considered the extent of the effect of opposing the catch condition on the respondent and his livelihood, and that is accepted, and I will come to that in a bit more detail in a moment. But, I mean, in short, the purpose of a Habitats Regulation Assessment, which is what that document was, is to assess what the impacts are on the protected European sites. And social and economic considerations are only relevant where you're applying Regulation 62, which is looking for imperative reasons of overriding public importance, which has never been suggested to be relevant to this case. So it is correct, and I accept that the Habitats Regulation Assessments did not consider expressly the livelihood of Mr. Mott in relation to the catch condition. And then 35 touches on points I raised right at the beginning, which is to deal with the fact the Court of Appeal held that the expert evidence and the assessments upon which we based our habitats regulations were considered to be rational, and that's dealt with in further detail in 35. Can I then ask you to go just...
Could I just ask an idiot question? I'm sure it's answered somewhere in the volumes of material that we have, but how is it that a fishery upstream of the River Wye affects, as I understood it, salmon?
This was one of the highly contested issues below. The reason is that I'm going to give my own version of the scientific explanation for this, but the salmon use the ebbs and flows of the estuary to travel. So when it's on the flood tide, they travel up the estuary, and that may take them
and it may take them a bit further, yes.
And then they use the ebb tide as they come back to enter their rivers. Now, there was also evidence that sometimes the salmon can go up and down several times before they will enter their own river. But that's the explanation. This was one aspect which the judge below thought was lacked evidence, and therefore there was a rationality issue around, but the Court of Appeal concluded that there was a rational basis for the agency to take that view. So that's the explanation. I have to say, I agree with my lady, when one looks at it, first of all, one is sort of bewildered as to how that is the case.
Well, I was concentrating on the legal issue that there is in this case, and I wasn't concentrating on the massive factual detail, but it was an obvious question.
That's the explanation.
Thank you.
And the context is that the tide rates are extremely high in this part.
Yes. So it's not surprising that the fish would be carried further in before they were able to flow back. As I understand it, it's a method of saving energy by the fish to actually use the tides to come in and out rather than swim against. Can I then just turn to the habitats regulation assessments themselves, which we'll find in Core Bundle 2. It's page 245 of the hard copy. It should be electronic bundle 361.
What was the paper
page?
Sorry, the paper was page 245 in Core Bundle Volume 2.
You appear to be correct about 361.
Okay, that's good. Well, I'm adding.
This
I'm
is
adding.
the assessment form. Yes,
The appropriate assessment form for
Yes.
new applications.
Yes, this is the 2012 assessment. The other two assessments are in materially similar form. So I'll just look, if I may, briefly at the 2012 version. You'll see at the top of the page, towards the top of the page, there's a heading type of PPP, which is type of permission plan or project, and that's kind of capturing the language of the habitats regulations. And you'll see it's described as the operation of fisheries to catch salmon in the Severn estuary. So the assessment was looking at fishing across the estuary as a whole. And you'll see it then says below that, Severn Estuary Salmon Fisheries 2012, a fishery consisting of 3 discrete components. And the first one is the historic installation fisheries. You've then got 2, the lave net licences, and then at 3, the draft net licences. And then over the page, if you go to page 247 in the hard copy, 363 in the electronic bundle, you'll see in the first paragraph there's a reference to the historic installations, and it says no more than 5 have been licensed in the past 10 years, of which no more than 3 are anticipated to seek a license in 2012, and then it refers to the other nets in the next paragraph. And then it says all of these fisheries exploit a mixed stock, and you'll see some information set out there about the genetic analysis which comes from the Exeter report. I won't spend time on that. If you go to page 249 in the hard copy, 365 in the electronic bundle, you'll see there's a list of features. So these are the relevant features of interest for these designations, and you'll see at 2.5, Atlantic salmon is one of the designated features for the River Wye, and obviously the potential hazard, not surprisingly, is the killing of fish or other animals in relation to Atlantic salmon. And then at page 251, 367 of the electronic bundle, there's a heading discussion at the top of the page, and a number of points are then made in some detail about the conservation objectives of the relevant SACs, and a discussion that goes on for several pages. I'm not going to go through the detail, I'm going to just go to the conclusions, but if you go to page 252, electronic bundle 367, you'll see in the middle of the page, so electronic bundle would be 368, hard copy page 252, you'll see the conditions proposed for 2012 in the middle of the page. HI fisheries, which is historic installation fisheries, 30 fish per licence, and then for the lave nets, 5, and for the draft nets, 2 fish. And that gives the total, which one sees on the table on the next page, of a Severn estuary catch of 221. If you add up, it's 3 historic installation fishery licences are assumed, 25 lave nets at 5 fishes each, and then 3 draft nets at 2 fishes each. A number of other factors are considered in the conclusions. If I could go to those, page 254 of the hard copy, 370 of the electronic bundle. You'll see it says conclusions for fisheries. We concluded that the potential scale of magnitude of the effect of unlimited catches of salmon was likely to have a significant effect on European sites. We therefore intend to set conditions to limit the numbers of fish that are caught. There's then reference to the Exeter report in the next paragraph. Then the third paragraph, our assessment is that recent and future potential unconstrained catches of salmon in the estuary threaten the integrity of the European sites, particularly the River Wye. Then nevertheless, we recognise the heritage value of the fishing methods used in the estuary, some of which are wholly unique to this site, and we accept that some residual exploitation of salmon will take place, but consider the residual catch as sustainable and therefore acceptable, and therefore a number of restrictions are going to be imposed, including the conditions on historic installations. And then the overall conclusion, we've considered the likely level of catch and conclude this will have no adverse effect on integrity. So the agency identified a level of catch for the estuary that wouldn't affect the European sites, and you've seen the way it was proposed to divide that out. And then on the next page, EB 372, hard copy 256, the conclusion is set out again. Can it be concluded there won't be an adverse effect? Yes, if one imposes the relevant conditions. And on the next page, 257, Electronic Bundle 373, you'll see that the Countryside Council for Wales, who were then the equivalent of Natural England in Wales, commented that they agreed with the outcome of the assessment, that if those conditions were imposed, there would be no harm to the integrity of the European site. As I say, you've then got the other habitats regulation assessments that carry on after that. They are in materially similar form. I'm not going to go through those for the purposes of today. So ultimately, if I can just conclude on the facts, the view taken by the agency was that there was a need to impose catch limits based on expert evidence, rational expert evidence, and indeed the agency considered those catch limits were necessary to protect the salmon stock and to prevent damage to the integrity of the River Wye SAC. That was the basis upon which the decisions were made. Can I then turn to my second heading, which is the legislative background? And I said I would deal first with the 1975 Act. For this, we need the separate bundle of legislation, and that starts, in terms of electronic bundle, page 2179, I think it should be. And we have here section 25, which is the relevant section under which the...
Sorry, what's the
Sorry,
electronic number?
It's tab 1 of the legislation bundle, first page, and it's electronic bundle, it should be 2179.
Yes, that is part 4 of the
Yes.
Salmon and Freshwater Fisheries Act 1975.
Yes, correct.
That's what you want.
I've just looked for the paper copy of this earlier on. I've got 4 bundles of authorities. Is one of them the...
No, there was a separate legislation bundle.
I grabbed a slim one.
It's a slim, yes, it's the
Got it.
slimmest of all the
Got it,
bundles.
got it. Thank you.
And in that, it's tab SB1, the very first page of SB1.
Now, what's your purpose in taking us to this legislation? Because obviously you have power to do this, and it's been accepted that your use of the power was rational, not Wednesbury unreasonable. So what's the purpose of taking us to the legislation? I just want to know why you're doing that.
Well, one point I do want to make is that there are obviously provisions within these acts where there is a requirement to compensate, or where Parliament specifically directs that there should be consideration given to whether compensation should be paid. And my point is that none of that is present in section 25. Now, I'm not saying that's decisive, and certainly not in terms of my Human Rights Act arguments, but nonetheless, the legislative scheme here is that Parliament has, in places, introduced an entitlement to compensation specific to the use of certain powers, and in others, specifically directed the agency to give consideration to whether it should pay compensation. But in section 25, which is the section we're concerned with, all of that is absent. And that's the only point I see.
Is there any study or white paper or anything else which explains why some cases are treated as compensation, or is it purely historical?
Not that we've been able to find, no. And I mean, we haven't, I have to say, we've not sought to look at Hansard in relation to this. But we haven't found any white papers or anything that explains the difference in the
And
provision.
it's not at all dependent, is it, on the European law background? Or?
Well, my lord, not that I can detect in terms of what the submissions I'm going to make.
So where are we looking?
So, my lord, if we just look at section 20, my lord, if we look at section 25, licences to fish, there's a subsection on the second subsection 1, which is the one in square brackets. This has all been introduced by the 2009 Act, and you'll see it says the appropriate agency shall, by a means of a system of licensing, regulate fishing by licensable means of fishing for salmon. And then in this Act, licensable fishing includes, you'll see at 1AB, an historic installation. And then in 1B, you'll see historic installation is defined. And then if you go over the page, electronic bundle 2180, sub 8, schedule 2 of this Act shall have effect with respect to fishing licences. And if you then go to Schedule 2, which is towards the back of this tab, it's electronic bundle 2187, although I think on the printed copy it says 2186. And you'll see Schedule 2, 14A, 1, where a fishing licence granted in respect of an historic installation, the appropriate agency may at any time, subject to the paragraph, impose conditions on its use pursuant to the licence. 2, they must be imposed by notice. 3, the notice can be varied or revoked. And then 4, the appropriate agency may only impose the conditions above where it considers it's necessary to do so for the protection of any fishery. And then if I could ask you to go back in this tab to section 26, which is in the electronic bundle 2182, it's probably 2181 in the printed version. You've got section 26, so the section that follows our section, which deals with what are called net limitation orders. And in short, those are orders which can be made by the agency which restrict the number of licences that can be granted for certain types of fishing. And that's all dealt with in sub 1. But you'll see that at 1B, you can't make a net limitation order in respect of an historic installation. So that's 1B. So that wasn't an option that was open in this case. And then over the page, at sub 4, and sub 4 appears also to have been inserted by the 2009 Act, or substituted by the 2009 Act. You'll see 4 says, if it appears to the appropriate agency that an order under this section would prevent a person from fishing. So it's not limit, it's prevent, because the effect of a net limitation order is if you say only 6 licences can be granted in this area and 8 people apply, there are 2 people who will get no licence at all. So they'll be prevented from fishing. It says if they're prevented from fishing, in circumstances where that person's wholly dependent on the fishing for his livelihood, the appropriate agency may pay that person such amount by way of compensation as it considers appropriate. So that is a provision that's specifically there for net limitation orders, absent from section 25 in relation to historic installations.
Now, that provision, was that introduced in the 2009 Act?
That's what I understand, because if you go...
It's a bit difficult to work it out, isn't it? The square brackets are rather complicated.
Yes, because if you go to electronic bundle 2185, and I think it's 2184 in the printed version, about halfway down the page you've got, it says sub S4, substituted for sub S4 and 5 as originally enacted by the Marine and Coastal Access Act 2009, section 2181 and 5. So it does appear that the whole of 4 was substituted in, and then there's a further substitution in relation to appropriate agency by a later 2013.
Yeah.
But do we know whether the predecessor had compensation?
No, is the answer. We can check that.
It'd be worth checking that.
I think that'd be worth checking, because if these were amendments that were introduced in order to reflect certain things in the Habitats Directive, for example, but the previous Act had not done that, that could explain the rather selective amendment.
Yes, I mean, it could have, we will check that, but I mean, obviously it could have been that there'd always been a power to compensate
Exactly. That's what we're getting at.
for net limitation orders, and therefore that continued. But
So it would be good to know.
very well, we will check that.
If you're going to take us to this for this purpose,
Yes, we will.
we will explore.
We will check that. We will check that and come back on that.
You know, it sort of occurs to me that there's parallels with the sort of compensation provisions in the planning legislation, where you have a modification order which sort of imposes limitations on an existing permission, and you get compensation, whereas conditions on a grant permission obviously don't attract. But I mean, there's not a very clear, the rationale of the dividing line between when you get compensation and when you don't is not always very clear.
And I mean, there's another example in the Planning Acts which is perhaps even more complex, and I probably don't want to go into any areas, but your Lordship will know about the provisions on old mining consents, where you had to apply for new conditions.
Yes.
And the new conditions, there was a procedure, but there wasn't compensation payable when new conditions were imposed that restricted your activity in a very significant way compared to previously.
I see. Well, it all comes back to me, but I suspect we'd better stick to this one.
That in itself is a subject matter which could take a lot of time
Yeah.
to unpick. So we haven't. We'll get copies of the Act as it was, but it doesn't appear to have been previously a right to compensation.
Oh, that's interesting.
So,
I mean, it suggests that there's some sort of I'm surprised there isn't some European EU background to this, because most of our environmental law comes from EU law and is going to be retained post-Brexit. And it seems surprising that this issue hasn't been considered at that level.
well, not that we've been able to find, and it hasn't been, as far as I know, it wasn't referred to in the courts below either as submissions. So we haven't been able to find an explanation for that.
Right, thank you.
Now, in terms of legislative context, I'm not going to spend any more time on the other domestic provisions. You'll have seen from Mr. Mott's written case that reference is made to some other powers that exist, for example, under the Water Resources Act 1991, to introduce bylaws or to compulsorily purchase fisheries. And the point that Mr. Hockman makes is that those provisions do allow for compensation, perhaps not surprisingly for compulsory purchase, but there is also, Mr. Hockman says, some ability to compensate for bylaws. It's a different act, and I'm not sure how much we're assisted by looking at what other powers do in other acts. There's certainly no argument that's been made, and in my submission, nor could there be, that we were barred from using the conditions because they don't provide automatically for compensation, and we were required to use some other power that did provide an entitlement to compensation. That was the argument that this court considered in Harrow and Cusack as to whether one is required. If one's got two powers, do you have to use one that provides for compensation? And that's not been part of the argument to date in my submission. Can I then turn to the habitats context in terms of the legislation and deal with that briefly? In the same bundle, should have at tab 4, SB 4, relevant extract start. It's electronic bundle 2209, and on the printed copy it will say 2208 is where the relevant extracts start. But I would like to go straight, if I could, to page 2211 in the printed and probably 2212 in the electronic bundle, Regulation 61 of the 2010 regulations. So this implements Article 6.3 of the Habitats Directive, and you'll see 61.1 says a competent authority, before deciding to undertake or give any consent, permission or other authorisation for a plan or project, which A, is likely to have a significant effect on a European site, B, is not directly connected with or necessary for the management of that site, must make an appropriate assessment of the implications for the site in view of that site's conservation objectives. And that process is sometimes referred to as a shorthand of undertaking a habitats regulation assessment. And then you'll see at sub 5, in the light of the conclusions of the assessment and subject to Regulation 62, considerations of overriding public interest, the competent authority may agree to the plan or project only after having ascertained that it will not adversely affect the integrity of the European site. And then 6, in considering whether a plan or project will adversely affect the integrity of the site, the authority must have regard to the manner in which it's proposed to be carried out or to any conditions or restrictions subject to which they propose that the consent, permission or other authorisation should be given. So in short, you can't grant any consent, permission or authorisation if you consider that it is A, likely to have a significant effect, and B, having undertaken an appropriate assessment, you're unable to conclude that there will be an absence of an adverse effect on integrity. In that situation, you can't, subject to Regulation 62, grant the consent, albeit in deciding whether there would be an adverse effect on integrity, you can have regard to the conditions, perhaps not surprisingly, the conditions and restrictions that are imposed. And then just briefly on 62, which is over the page 2213 or 2214 in the electronic bundle. Regulation 62, which is the exception to the requirement to refuse where you consider there will be an adverse effect. It says, sub 1, if the competent authority are satisfied that there being no alternative solutions, the plan and project must be carried out for imperative reasons of overriding public interest, which, subject to paragraph 2, which is actually not relevant to us here, may be of a social or economic nature. They may agree to the plan or project notwithstanding a negative assessment of the implications for the European site. So the only exception to the very strict requirement to refuse, if you consider there's going to be an adverse effect on integrity, is where there is what is called an imperative reason of overriding public interest. And not surprisingly, that is a high test, a high threshold, to allow you to do something that's damaging the integrity of a European site. And it's only there in 62.1 that economic, social considerations come into play. Apart from that, the habitats regulations and the directive on which they're based are concerned not with the social and economic, they are concerned with the impact on the protected sites. Now, in the bundle you have, in the authorities bundles, I don't ask you to go to it, but we've provided the European Court's decision in Sweetman, which contains a summary of the objectives and requirements of the Habitats Directive, which these regulations implement. And can I just make 3 short points? I don't ask you to go to it, but first of all, at the Advocate General's opinion, paragraph 37, the overall aim, the essential objective of the directive, is to require member states to maintain or restore to a favourable condition European designated sites. That's the overall objective, restore or maintain to favourable status. Secondly, Article 6 of the directive, which is what Regulations 61 and 62 implement, require, as we've seen, that you must refuse if you consider there's going to be an adverse effect on integrity, unless there are these imperative reasons of overriding public interest. And thirdly, the Court and the Advocate General emphasised the tests imposed are strict ones on a precautionary basis for the protection of the environment. Can I then turn to the judgment of the Court of Appeal below on the issues that we're concerned with? I'll ask you to go in Core Bundle 1 to page 3 in the appendices, Appendix C. It's electronic bundle. It starts at 119. The judgment, but the part that we're concerned with on Article 1, Protocol 1, is at page 140 in the electronic bundle, 24 in the hard copy, Core Bundle 1. And paragraph 83, Lord Justice Beatson records that the determination of whether there was a breach of Article 1, Protocol 1 is not straightforward. And the court proceeded on the assumption, which again I ask your lordships to proceed on, and your ladyship, that the agency could properly have imposed the total catch limits that it did, i.e. to reflect the judgment on rationality. So that's paragraph 83. In paragraph 87, the court concludes, 4th line down, the interference is closer to deprivation than mere control. And you'll see it said there's some 6 years after the first of the challenge decisions and less than 2 years from now, the lease will expire. And then you'll see it says, even if the interference is only a control, it does not follow that because it was made on environmental grounds, that any restriction can be made without compensation. And then the Court of Appeal deals with a case I'm going to come to in a moment, Trailer and Marina, and says that that doesn't provide, as we argued, the basis for concluding there will be no requirement for compensation where environmental objectives are being pursued. And then paragraph 89, having dealt with Trailer and Marina in 87 and 88, paragraph 89, the court concludes no evidence that we considered the effect on livelihood. The method chosen of levelling all the permitted catches down to the previous lowest meant the greatest impact fell on Mr. Mott, and others whose rights were less extensive were affected less. And the court said in those circumstances, even if the agency could properly have imposed the total catch limit it did, I agree with the judge that the extent of the limit and the way it was apportioned meant in this case, in the case of Mr. Mott, a breach of Article 1, Protocol 1 could only be prevented by the payment of compensation. So given the way in which we proceeded, the conclusion of the Court of Appeal was we could only do that with compensation. And that led to the declaration that the Court of Appeal then made, which is in the core bundle at Appendix A, back on page 1 of the appendices, Electronic Bundle 117. You'll see the declaration that the court made at paragraph 3 was that the decisions in issue were unlawful interference with Article 1, Protocol 1, in the absence of compensation. And my lady, my lords, that's obviously the conclusion which we seek to overturn. And I turn then to Article 1, Protocol 1. The court will know that the parties are agreed on 2 points, which are, first of all, that Mr. Mott's lease constitutes a possession, and secondly, that the conditions were imposed to serve a legitimate and lawful purpose, namely conservation of salmon stocks and the protection of European sites and the environment. That's agreed. The only issue between us is whether the catch limit conditions are justified in the sense that they strike a fair balance under Article 1, Protocol 1, absent compensation. And on behalf of the agency, I want to make good 5 propositions from the voluminous case law. So I'm going to state the propositions and then go to only a selection of the cases, if I may. But the 5 propositions are, first of all, in almost all the Strasbourg cases, the court has classified the alleged interference as being either a control of use or a deprivation. And linked to that, it's only in a very rare case that the court has found that a particular interference can't be fitted into either of those 2 categories and is therefore dealt with under what is said to be the first sentence of the first paragraph of Article 1, Protocol 1, as just an interference with property rights more generally. But my first proposition is that in almost all the cases, the court does classify as either control of use or deprivation. And by deprivation, of course, I include there not just formal deprivation, i.e. expropriation, formally affected, but also de facto. So that's included within that. Secondly, the distinction between an interference which is classified as a control of use and one that's classified as deprivation is a critical distinction under Article 1, Protocol 1, because we say while compensation will almost always be required, other than in exceptional circumstances for a deprivation, in contrast, we say as a general rule, there's no requirement for compensation to be paid for a control of use in order for the fair balance to be struck. So that's the second point, that's why we say the distinction is critical. Can I just add a footnote in relation to that? When we look at some of the cases, which we will do in a moment, there are control of use cases where compensation was payable. And obviously where compensation is paid for a control of use, that is highly material to and relevant to whether the fair balance is struck. But it's not generally held to be a requirement for a control of use. Thirdly, for an interference to be classified as a de facto deprivation, what's required by the case law is the claimant be left with no meaningful use whatsoever of his or her possession. And that is a very high threshold, we say, for that classification. And so there are two things that fall out of that. I mean, one is there are numerous cases, I'm going to show you a handful in a moment, where measures taken, for example, revocation of licenses, have had very serious and significant impacts, financially and otherwise, on people and on their property interests, but have still been held to be controls of use. And secondly, so far as we can see, there's only one case where the court actually concluded that there was a de facto deprivation, and that's the Greek military case, which I can never pronounce, but we'll come to a bit later on. That's where the Greek military, without any formal expropriation, just took over somebody's land and built a naval base on it and occupied it for 40 years and refused to give it back. Now, Sporong is another case which I'm not going to come to in any detail, but that's not a case of de facto deprivation. Sometimes people say it is, but that was actually a case where the court found that it was neither a control of use nor a deprivation, but fell within this third amorphous category. But the point I make, my third proposition, is it's a very high test for de facto deprivation. It does mean extinguish all meaningful use. Fourthly, I say this, planning and environmental laws regulating and limiting the use of land have in almost every case, certainly all the cases that we've got before us, been classified as controls of use, not de facto deprivations, even where they affect very severe restrictions. And then fifthly, we do say, as a fifth proposition, and on this we will go to Trailer and Marina, that as a matter of principle, the state should not, under Article 1, Protocol 1, be required to pay individuals compensation in order to stop them carrying out activities that are harming the environment, in particular, harming our most protected environmental assets.
Well, that's a kind of policy point. It's not really a... Is it a European point?
Well, my idea, in my submission, it is obviously a policy point, but I say it goes further than that, because what I say Trailer and Marina in particular, in the Court of Appeals decision stands for, is a general principle that you are not required under Article 1, Protocol 1 to pay compensation to stop people doing activities that are damaging the environment, or at least where you're talking about very important aspects of the environment. So I do say it goes further than that.
Are there cases under the European Convention which suggests that in a proportionality balance, and that applies, the environment has a special weight or protection of the environment?
There are some cases which mention, we'll come to, I think when we look at Frieden in a moment, it talks about the environment being an increasingly important aspect of what governments need to do. So there is some recognition of that. And there are some other cases in the bundle, I'll come to a couple of them in a moment, that deal with environmental being a particularly important part of the activity of government and therefore relevant to the fair balance being struck.
And there's nothing that links that in with the controls under the EU rules?
No, my Lord, nothing directly on that. And my Lord, the closest we've got, but I say the most useful authority is Trailer and Marina, but of course that was dealing with a national designation of SSSI rather than the European. So what I want to do is, before I look at the cases, can I ask you, I handed in this morning an extract from the Human Rights Practice, Emerson and Seymour. And I just by way of introduction, before I delve into some of the cases, can I just show you 2 or 3 passages in that? On the first page, after the title page, there's a heading, Control of Use. And you'll see...
Who is this by, I should know?
So this is written by Jessica Seymour and Ben Emerson, this book. It's a loose leaf that's updated on a regular basis, but Jessica Seymour and Ben Emerson.
It is usual to supply us with
Yes, I'm
a
sorry.
title page which tells us who the authors are,
I'm
because
sorry, I thought that was on the front page, but it's not. So
it's not, no.
It's not. It's blank. Yes, we will get that for you. I apologise. And you'll see on control of use 15027. There's above that is a heading control of use, and then 15.028 planning controls, planning legislation, including the imposition and enforcement of planning and land use restrictions, constitute controls of use for the purposes of Article 1, Protocol 1. And then there's a reference in the footnote to a huge list of cases, a number of which we've got in the bundles. But it then says planning regulations may have the effect of reducing the value of land significantly, but insofar as the land may be used for an alternative purpose and is not rendered worthless, the measures will constitute a control of use.
Well, that makes sense where the possession in question is land. But what if the possession in question is a mere proprietary right to use, as in the case of a fishing right?
Well, my lord, in my submission, the position is the same, and I'm going to make that good.
But you don't own the land, so I mean, Mr. Mott could not, with his licence, decide to make some other use of the foreshore, such as a place for swimming, ignoring the tides, or sailing, or any other kind of activity.
No, my lord, I accept that, but the test is it's only where the land is not rendered it's only where the possession is not rendered worthless and capable of no meaningful beneficial use. That's the way it's put in the cases. And one of the cases we will look at in a moment, Posty.
But are all these cases where the possession in question is land?
My lord, no, because Posty is a fishing case. And the same test is applied, which is, are you deprived of... I think the question was asked, is your right to fish completely extinguished, was the question the court posed.
We have lots of examples of commercial and economic rights in the lower paragraph.
Yes, I mean, some of these are... I mean, for example, some of the cases I'm going to come to in a moment are about licences for restaurants, which once the licence went, the restaurant closed and the economic interests...
I mean, hunting rights are very familiar. Cases on hunting rights in France are very popular.
Yes, that's when people had to allow hunting on their land in France, as was the Chassagne case. And then you'll see environmental measures on 15029. Similarly, environmental measures such as the imposition of reforestation obligations, the designation of land as a protected natural site, that's the Ullman's case is referred to, and I think Trailer Marina, or a requirement that landowners allow their land to be used for hunting, my lord, that's the example my Lord Carmouth just mentioned, in the interest of encouraging rational management of game stocks, and the introduction of fishing restrictions, that's Posty, which we'll come to, have been found to constitute controls of use. And then if you go to the next page, should be 15060. You'll see there's a heading compensation. The payment of compensation will be highly relevant to the fairness of the balance achieved. As regards deprivations, a fair balance impliedly requires compensation in all but the most exceptional circumstances. By contrast, no inherent right to compensation for controls of use, nor by extrapolation for interferences with peaceful enjoyment that do not amount to deprivations. However, when assessing proportionality of the regulation in question, it will be of relevance whether compensation is available and to what extent a concrete economic loss was caused by the legislation. And then there's a reference to Trailer and Marina, and I'll come to that case in a bit more detail, but you'll see the quotation is, the right analysis seems to us to be that provided the state could properly take the view that the benefit to the community outweighs the detriment to the individual, the fair balance will be struck without any requirement to compensate the individual. Should this not be the case, compensation in some appropriate form may serve to redress the balance so that no breach of Article 1 of the First Protocol occurs, and I'll come back to that in a bit more detail. And then similarly, can I ask you, before we go to the cases, if you go in the authorities bundle to the last bundle 4, tab 46, which starts in the electronic bundle at 2161. This is the article by David Anderson on compensation for interference with property rights. So it's bundle 4 of the authorities, tab 46. And the relevant passage starts at electronic bundle 2166, or in the printed version it'll be 2165. And under the heading control of use, you'll see the third category of case is subject to a different rule in relation to compensation, one far less favourable to applicants, where state interference is deemed to take the form of a control of use. There is no presumption in favour of compensation. The availability of compensation is simply one of the factors that has to be taken into account in determining whether a fair balance has been struck. And then in the next paragraph, there's a reference to Boehner in Sweden, which I'm going to come to. And then in the next paragraph, in many cases, the Strasbourg organs have concluded a fair balance has been struck between private and public interests, notwithstanding a failure to compensate for a reduction in the value of the property affected. The subject matter of such cases includes, there's a whole series of cases, some of which we're going to look at, revocation of a gravel extraction permit, withdrawal of planning permission, public health legislation made it impossible for the applicants to carry on their business of deboning cattle heads, and that's the Pinnacle case. And then so the practice of the Commission and the Court therefore demonstrates there's some truth in the Commission's statement that the control of use does not, as a rule, contain any right to compensation. It might even be said on the strength of that dictum that in relation to controls of use, there's a presumption against a requirement to compensate. This is probably an over-rigid interpretation of the case law, however. It would be more accurate to say that in relation to controls of use of property, the prior payment of compensation is just one factor among many in the assessment of proportionality for the purposes of Article 1, Protocol 1. So I want to, with that in mind, then turn to the cases. And what I want to do is look at 4 Strasbourg cases very briefly, looking at the time, and then two English authorities in a little bit more detail. So can we start with the case of Boehner and Sweden, which is Authorities Bundle 2, tab 19, EB 1324. So Authorities Bundle 2, tab 19. And it should start at EB 1323. Now, this is a case which we saw mentioned in the Anderson article. The relevant passage is on page 140, Electronic Bundle 1337. Now, this was a fishing case, quite different to our case, because the legislation in Sweden required that owners of lakes or the foreshore rivers were no longer able to charge people to fish on their land. They had to allow the public in for free. That was the measure that was in issue in that case.
This is a commission decision.
It's a commission decision. And the reason I go to it is that the statement that we saw a moment ago in the Anderson article about the general rule on control of use cases is generally thought to have derived from this case, which is what, and this case is cited in a number of other authorities. And I want to just go to 2 passages which are relevant to the principles, I say. First of all, as I said, page 140, Electronic Bundle 1337, at the bottom of the page, paragraph 6, the Commission considers the restrictions must be examined under the control of use rule. The applicant argues the second paragraph cannot apply since the 85 reform doesn't involve any true control of use, which he has made of his property. However, the French text speaks of réglementaire lesage de bien, which more accurately describes what, in the Commission's view, must be the purpose of the second paragraph. This provision must be understood to permit the enforcement of laws which are deemed necessary to regulate the use of property. So that's what the Commission say, and it's been picked up in later cases, is the proper purpose of the control of use limb. And then if you go to page 142, Electronic Bundle 1339, you'll see that the paragraph towards the top, the applicant stresses, it's a sort of first full paragraph, the applicant...
Wait, can you give me the page number?
Sorry, it's 1339 in
Thank you.
the electronic bundle,
Yeah.
and 142 in the hard copy. Towards the top of the page, the first full paragraph starts, the applicant stresses that since he did not receive any compensation, the requirement of proportionality was not met. It follows from the case law of the convention organs that as regards deprivation of possessions, there is normally an inherent right to compensation. And some cases are cited, and it says, however, in the Commission's view, such a right to compensation is not inherent in the second paragraph. The legislation regulating the use of property sets the framework in which property may be used and does not, as a rule, contain any right to compensation. The general distinction between expropriation and regulation of use is known in many, if not all, convention countries. And then the next paragraph, this does not exclude that the law may provide for compensation in cases where a regulation of use may have severe economic consequences to the detriment of the property owner. And the Commission is not required to establish in the abstract when Article 1 may require compensation to be paid in such cases. When assessing the proportionality of the regulation in question, it will be of relevance whether compensation is available and to what extent an economic loss was caused by the legislation. So that's the source of the general rule, as it's referred to, or the rule of thumb, that there is no requirement for compensation in control of use cases. Can I then ask you to go in the authorities bundle back to bundle 4, tab 43, and that's electronic bundle 2089. Which should be Trattatore in Sweden, which is another case that's, I think, often cited in Article 1, Protocol 1 cases. This was a restaurant which had its licence to sell alcoholic drinks revoked following tax investigations, and that caused the restaurant to close down. And the relevant issue, so far as we're concerned, is that a control of use or a deprivation, de facto deprivation? And the relevant passage starts at 323 of the hard copy bundle, page 323, electronic bundle 2103. And I just note in passing, in paragraph 53, the court took the view that the economic interests connected with the running of the restaurant were possessions, i.e. the goodwill of the business, etc. That was what the possession was considered to be. But for our purposes, on that same page, B, the Article 1 rule applicable to the case, we've then got that standard paragraph which appears in, I think, nearly all the Article 1, Protocol 1 judgments about the 3 rules. And then 55, severe though it may have been, the interference at issue did not fall within the ambit of the second sentence of the first paragraph, that is, deprivation. The applicant company, although it could no longer operate Le Cardinal, which is the restaurant, as a restaurant business, kept some economic interests represented by the leasing of the premises and the property assets contained within them, which it finally sold in June 84. There was accordingly no deprivation of property. The court finds, however, that the withdrawal of the licence to serve alcoholic beverages constituted a measure of control of use of property that falls to be considered under the second paragraph of Article 1 of the protocol. And then on page 325, electronic bundle 2105, paragraph 61, in respect of this latter point, the court refers to its statement in paragraph 53 above. It sees no reason to exclude that the restaurant closed as a result of the revocation. And then the financial, same paragraph, the financial repercussions of the revocation were serious. The court thus agrees with the Commission that this was a severe measure in the circumstances. But the conclusion of the court in paragraph 63, page 326, 2106 in the electronic bundle was there was no violation of Article 1, Protocol 1, and there was, of course, no compensation payable for that revocation. So what the case, in my submission, stands as authority for is that even very severe measures with very serious economic consequences and which can cause a business to close down are not regarded as deprivations, but as controls of use. Then the third of my 4 Strasbourg cases is Frieden, which is in Authorities Bundle 3, tab 29.
Sorry, which tab?
Sorry, tab 29 in Bundle 3, Electronic Bundle 1719. And this is a case where you'll see from the head note on page 1719, the electronic bundle, first page of the tab in hard copy, the applicants owned a number of plots of land in Sweden which contained gravel pits. And in 63, Mr. Frieden's parents were granted a license to exploit the pit. In 73, a change in Swedish law meant the license could be revoked at any time once 10 years had elapsed from the date the law had changed. In 73, the applicants became the owners. In 80, they began to exploit the pit. They were granted some additional licenses, but eventually there was a revocation of the gravel pit extraction licenses, and they were told they had to cease. In 84, they were given some extensions and eventually ceased gravel extraction in 87. And the relevant parts, so far as we're concerned, page 792, electronic bundle 1727. You'll see there's a heading at the bottom of the page, A, the Article 1 rule.
Sorry, give me that.
Sorry, it's page 792 in the hard copy.
Electronic.
1727 in the electronic.
1727.
1727 it should be in the electronic.
It is.
Yes. So page 792 in the hard copy, you'll see there's a heading A, the Article 1 rule applicable to the case, and then we've got the standard paragraph on the three rules, which I won't trouble the court with. But over the page, 793, 42, paragraph 42, there was no formal expropriation of the applicant's property. However, for the purposes of Article 1, Protocol 1, the concept of deprivation also covers de facto expropriation. And then 43, the court notes the impugned measure was basically designed to control the applicant's use of their possessions, left unaffected their powers to take formal decisions within the normal boundaries of the law. Indeed, this was common ground. It remains, however, to be ascertained whether the consequences of revocation of the permit were so serious as to amount to a de facto deprivation of property. In 44, the applicants have stressed that the revocation, taken together with the other existing regulatory measures, left no meaningful alternative use for STROM 1.3, which is the relevant land. They've also maintained that the revocation deprived the property of all its value. Now, the court then, at 45, makes some observations about the fact that they owned other land around, which you had to also consider. And at the end of 45, it says, viewing the question from this perspective, the court does not find it established that the revocation, and this is obviously the test I rely on, took away all meaningful use of the properties in question, albeit, of course, these were gravel pits, and they could no longer extract gravel from them. And at 46, you'll see this third line, it recognises, so the court recognises, nevertheless, the revocation did have serious adverse effects as compared with the situation which would have obtained if they'd been able to continue to exploit gravel in accordance with that permit, on the income derivable from the possessions involved in this case, and also on their value. One has, however, to bear in mind that over the years, the exploitation of gravel has become more and more regulated and, in fact, restricted. So that's one thing that I do ask the court to note that has been relied on, is the growing regulation is something which was referred to as being relevant. And then 47, in the light of the above considerations, the revocation of the applicant's permit to exploit gravel cannot be regarded as amounting to a deprivation, but it constitutes a control of use of property. And just to pick up on a point that Lord Carmouth asked me earlier, if you look at 48, paragraph 48 on that page, second line, the court recognises for its part that in today's society, the protection of the environment is an increasingly important consideration. That was said, obviously, in 1991.
Which paragraph was that?
48, my lord, on page
Thank you.
794. And just one other reference. If you go on page hard copy 795, electronic bundle 1730, there's a heading, proportionality of the interference. And on the next page, 796 in the hard copy, 1731 in the electronic bundle, paragraph 53, the court notes the applicant suffered substantial losses having regard to the potential of the gravel pit if it had been exploited in accordance with the 1963 permit, but nonetheless the court found ultimately a fair balance had been struck. So that's Frieden, and then the final of the Strasbourg cases that I wanted to go to is Posty, which is perhaps the closest to our facts, and that's in Bundle 4.
It's quite interesting that one of the things they took into account was the 3-year closing down period and the measure of flexibility.
That's one thing they were, absolutely, yes. That's one thing they took into account in the fair balance, was that there was a period of grace.
It wasn't suddenly dropping off a cliff, yeah.
Correct.
To a page. Right.
I'm sorry, yes, in the electronic bundle, it's EB 2028. So this is Bundle 4, tab 41.
2028, did you say?
Sorry, I said a moment.
2028.
2028, I think. Let me just check I've got that right. 41.
Yes, you have.
So, yes. So this is Posty and Finland. You'll see from the head note on the first page, the applicant fishermen operated in the coastal region of the Gulf of Bothnia under leases granted by the state, relying on Article 1 First Protocol, both alone and in conjunction with Article 14, they complained that restrictions imposed and maintained by governmental decree violated their right to peaceful enjoyment of their possessions, which allegedly comprised a right to fish in certain coastal waters of the Gulf, and also that they'd been discriminated against. And in relation to the facts, one can see them in a bit more detail. Page 163, EB 2033. You'll see paragraph 8. They fished in the coastal region on the basis of leases with the government. So there were leases to fish, effectively, paragraph 8. And paragraph 9, the government had power by decree to restrict fishing if this was deemed necessary in order to safeguard future fish stocks. And then, in terms of the relevant findings, page 175 of the hard copy, 2045 of the electronic bundle. So 175 hard copy, 2045 electronic bundle. And above paragraph 70, there's a heading, Article 1, Protocol 1, in isolation.
Well, that's without the discrimination argument.
Without discrimination, yes. 72, so in the alternative, the government observed the restriction emanating from the 94 decree might have constituted during that year an interference with the applicant's right to the peaceful enjoyment of their possessions under the then existing leases. The contested measure nonetheless amounted to a mere control of use of the possessions. Accordingly, assuming Article 1, Protocol 1 was applicable at all, only its second paragraph, control of use, could come into play. The fishing restriction aimed at protecting a limited natural resource which was in the general interest. And then you'll see it says also the state had an exclusive right to control the fishing of salmon and saltwater trout. This did not prevent the owner of a water area to fish other species within the limits set by the Fishing Act or European Community law. And then some further arguments are set out by the government and the applicants. And at 75, on page 176, 2046 in the electronic bundle, the court sets out its conclusions. So first of all, it found the first decree was out of time, so it was focusing on the later decrees in 96 and 98. And then 76, the court finds the applicant's right to engage in certain fishing on state-owned waters on the basis of their lease constituted a possession of theirs for the purposes of Article 1, Protocol 1. The limitation of that right through the 96 and 98 decrees amounted to a control of use of those possessions within the meaning of the second paragraph. The court finds essentially, for the reasons invoked by the government and the Ombudsman, that this interference with the applicant's property rights was justified, being lawful and pursuing by means proportionate to that aim the legitimate general interest of protecting the fish stocks. Moreover, the interference did not completely extinguish the applicant's right to fish salmon and trout in the relevant waters. And then it does also say, because in this case there was some compensation, the applicants also received compensation for losses as a result of the fishing prohibition by the 1996 decree. So one of the 3 decrees provided for there to be compensation. But what I draw from that is that the test in relation to facts which are closest to ours is that the question is, does it completely extinguish the fishing right? Because if it does, then it would be treated as a deprivation. But the court didn't treat it as a deprivation, it treated it as a control of use, albeit, no doubt, it will be said a severe one.
Well, I don't think the court was saying that it's a prerequisite for expropriation that it must be completely extinguished. I mean, it happened to be in that case that the fishing rights were not completely extinguished. But I don't think it's pronouncing any general principle, is it?
Well, in my submission, it would fit with what we've seen in the other cases, which is the distinction between deprivation and control of use depends on there being a complete extinguishment of meaningful use, is the way it's put.
What does meaningful use mean? Does that mean viable use? I mean, if you reduced it to 1 salmon a year, for instance, that's not a complete extinguishment, but would you say that that's not expropriation?
Well, 1 fish a year is obviously the difficult example. The test, though, is a very high one, which is getting rid of any meaningful use. You might well say 1 fish is not a meaningful use. Obviously, when we're going to come to it in a moment in terms of the facts of this case, I mean, what has happened here, of course, is that Mr. Mott, because of the restrictions that have been imposed, can't pursue commercial fishery activity. He is able to take, as we know, 30, 23, 24, whichever the relevant year is, salmon, which is, we would still say, a beneficial use. It's obviously very much reduced. I do not dispute for one moment that it's had...
When set against the cost of maintaining the equipment, I mean, is it still meaningful use?
In my submission, it is. And I also say that there are the possibility of other alternatives. And one of the things we'll look at in a moment that's referred to in one of the agency's documents is that those people operating butchers under continued licences have been encouraged to diversify into tourism, to take advantage of the heritage value. And that is another alternative use that could exist in relation to a fishery that allowed you to catch 30, 23, whatever number it is.
Sorry, can you explain that? Why would tourists want to come and see?
Well,
I mean, if you put these things in the water, presumably they catch fish. And the only way to stop them catching fish is not to put them in the water. So why would the tourists want to come and see them piled up on the land, as in that photograph?
Well, no, it would be the catching, because obviously you can catch a certain number of fish. So what the diversification that's referred to is, we'll come to the document in a moment, but what we're referred to is that those who are, because there are a number of people who are taking butcher licences for 30 fish or less, because that's where this restriction came from. It looked for the lower levels of people applying. And what are these people doing? Well, some of them are doing it for leisure or for their personal use. So some are taking the fish because that's a leisure activity or because they want to consume the fish themselves. But there are also examples, and the agency encourages this because of the heritage aspect, which is referred to in the HRA, of diversification into tourism, i.e. people actually saying this is a heritage activity, there is potential for people to want to see this.
But I'm not sure that answers my Lord's question. How does it work out in practice? I mean,
maybe the answer is that, he's got a licence to operate something like 600 of these baskets.
The lease for 650.
650, which broadly speaking caught 600 fish a year, although you don't accept the figures. So slightly less than 1 fish per basket. So I suppose if he reduced himself to 30 baskets, then the tourists will come and watch them catching the requisite 30 fish. That would be the suggestion. I mean, there is.
You say there's evidence that this is actually being done, so it's probably not for us to speculate about.
Well, I'll show
it's a sensible thing to be doing.
I can show it to you now, but I was going to come to it a bit later on in terms of what's said. I mean, it's simply a reference to an encouragement by the agency for diversification of this activity into tourist.
It does raise a question which has been at the back of my mind, may not arise, is whether this is not a matter for the, in these marginal cases, whether it's not a matter for the trial judge, and whether the appellate court shouldn't be adopting the sort of approach we said it should adopt, proportionality, which is not interfering unless the judge has gone wrong.
Well, my lord, I mean, save that whether the fair balance is satisfied is, I think this court has held a legal question for determination by the courts, and therefore...
Oh, definitely by the courts. The question is whether
Which
the
court?
appellate court
Which court?
can interfere with the...
I mean, it may be, there's a case called Re B, which is quite sensitive in this court, but it does say, the majority apparently say that the question of proportionality is a thing on which the appellate court should not adopt its own view unless it can see something wrong with the first court.
Yes. I mean, I will show you this. The trial judge did make a finding that the conditions didn't entirely extinguish the fishing rights, that it could still be used for leisure purposes. And he also referred to the fact that other people applied and obtained licences to obtain that number of fish or less.
So he'll show us that.
But yes, I will show you. But still on that basis, the judge still
He still said it
concluded-
was a...
Still said that
Yes.
it was...
So you said he went wrong.
yes, because the legal test is complete extinguishment of the beneficial use. That's posty. Can I come to the two English authorities that I wanted to go to? So first of all, British American Tobacco, which is in volume 2, tab 12, and it starts at electronic bundle 1105. The facts are set out in the head note. I don't think we need to trouble ourselves with them too much. They are, I would accept, very different from our current case. They were to do with the restriction on the use of trademarks for cigarette brands based on restrictions on packaging for cigarettes. And so the Article 1, Protocol 1 issue related to the trademarks. What I want to do is just to go to what the Court of Appeal said in terms of the principles on Article 1, Protocol 1. And for that, starts at paragraph 91 of the judgment, electronic bundle number 1135. For those who've got the hard copy, it's going to be 1134 in that top right-hand corner.
Is this a judgment of the court?
It's a judgment of the court. Yes, just give me one moment.
Well, I've seen a we.
Yes, it's on electronic bundle 1112. Lord Justice Lewison handed down the following judgment of the court. So it was Lord Justice Lewison, Lord Justice Beatson, and Sir Stephen Richards. And at paragraph 93, you'll see the court says one of the critical distinctions, therefore, is between a deprivation on the one hand and a control of use on the other. Plainly, one highly relevant factor in considering whether an interference amounts to deprivation or control of use is whether the complainant has retained legal title to the possession in question. But even if the legal title is retained, the court has recognised there can be what is called a de facto expropriation. And then there's some discussion of case law, and you'll see at 95, paragraph 95 over the page, so 1136 in the electronic version, 1135 hard copy. There's a reference in the middle of paragraph 95 to Papadopoulos and Greece, and that's the case where the military just waltzed in and took somebody's land and built a naval base on it, albeit they never took any. Sorry.
Mikolopoulos.
Better attempt than mine. But you'll see that the Greek Navy effectively took over the land, built a naval base and a holiday resort for naval officers on it. They never took any formal title, and when they were ordered to give it back by the courts, they just simply didn't do so. And that is, I say, the one example where the court have actually found their high test for de facto deprivation is met, and perhaps not surprisingly on those,
I was going to say,
on those
it'd be
facts.
difficult to find otherwise, wouldn't it?
Well, it would be impossible to find otherwise. Effectively, it certainly meets the test of extinguishing all meaningful beneficial use because the land is gone. And paragraph 96, same page, one part of the test for deprivation as opposed to control of use is whether following the interference the complainants retained any meaningful use of the possession in question. If the answer to that question is yes, then the interference is unlikely to amount to a de facto deprivation or expropriation. Some cases are referred to, and then it says the rights may lose some of their substance, but provided they do not disappear, it's unlikely the interference will be treated as a de facto deprivation. So in my submission, that supports the...
I mean, the word meaningful use there, is that the Court of Appeal's expression, or does it come from any of those cases?
Well, it's probably the Court of Appeal's summary of what those cases say, rather than any taking it directly. But I mean, it is very similar to some of the language we've seen in the cases I've shown you about retaining any beneficial use or any meaningful use.
Well, it'd be quite
Well, it's 44 and 45 of the Frieden and Sweden case use that phrase. One being the applicant's assertion and the other being the court saying, no, it didn't.
And then 97, you'll see on the other side of the line, even where the complainant does lose legal title in question, it doesn't necessarily amount to a deprivation as opposed to a control of use. It refers to PI, which is obviously the case on adverse possession. And then 98, we were also referred to a series of cases which dealt with removal or cancellation of licences or the banning of the sale of goods, which were vital to the continuing viability of a business. In Pinnacle meat processors, the ban in question was a ban on the sale of meat deboned from the heads of cattle, which was introduced following the BSE crisis. Although the complainant was forced out of business and thus lost its goodwill, the Commission nevertheless treated the interference as a control of use. Now, I'm not going to go to Pinnacle, but I just want to pause and say one thing on that. There were actually a number of businesses that were applicants in the Pinnacle case, and 6 of them ceased trading entirely because their business was effectively rendered illegal. 3 of the others carried on by attempting to diversify into pig head deboning as an alternative. But for 6 of the businesses, they were completely put out of business by the provision, albeit they were able to sell the bare assets of the business, the machinery and stuff, but that their business was ended, complete loss of goodwill and those other economic interests in the business. And then you'll see, having said they were forced out of business, lost their goodwill, one of the points that is made, that it was still open to the complainant to use its tangible assets in an alternative business. And then the Edgar case is referred to, where a ban on firearms, the complainant suffered a large drop of turnover, claimed the loss of goodwill. This was a control of use, not a deprivation. And then Eastside Cheese, an order was made prohibiting dealing in cheeses which were thought to be unsafe. The effect of the order was to paralyse 2 businesses which processed cheeses, and the Court of Appeal held the case should be regarded as a control of use rather than a deprivation, not least because the order did not transfer ownership and was made with the object of restraining the use of property in the public interest. And then at paragraph 100, third line down, having gone through some of the other cases, third line down, we thus accept the submission of Mr. Eadie on behalf of the Secretary of State that whether the alleged interference is part of a general scheme of regulation is of significance in deciding whether the interference amounts to a deprivation or merely a control of use. And then finally, just on this authority, paragraph 113, so electronic bundle 1139, hard copy 1138, but paragraph 113 follows in our judgment question of whether the interference was justifiable force to be determined on the basis that regulations amounted to a control of use, not a deprivation. We accept that even if an interference amounts to a control of use rather than deprivation, it's possible in principle for compensation to be required if the control is sufficiently severe. And then an illustration of this in the domestic context is Mott, so our case. Of course, Lord Justice Beatson was in both this case and in Mott. In practice, however, a requirement for compensation is rare in a control of use case. The question in each case is one of proportionality. Is compensation required in order to achieve a fair balance between the public interest pursued and the private property interests affected? What I would just ask you to note briefly is that obviously here, the Court of Appeal is looking at Mott and saying that was a control of use case. When we looked at what the Court of Appeal said, they said it was closer to a deprivation than a control of use, but even if it was a control of use, they would still have required, said compensation was required.
Does a distinction need to be drawn between means and effect in this context? I mean, one can see how control of use is a means to achieve, for instance, the protection of public health. But if its effect is to completely deprive the cheesemakers of their livelihood, then that might be said to be expropriation.
Yeah, well, my lord, the answer is yes, if it meets the relevant test, which is, as I've put it, the extinguishment of all meaningful use of your possession, then that would meet the test for being a deprivation. But the 2 points I would make is that is clearly set at a very high level, as all of these cases illustrate. And that is also illustrated by the fact that we've only actually got one example, I say, from the Strasbourg cases, the Greek military case, where the court have found that test to be met. In all the other cases, despite there being very, very severe and significant restrictions imposed, having quite significant effects on individuals, and including ending businesses, they've been held to be controls of use, because there hasn't been a removal of all meaningful use or all beneficial use of the...
Is there any definition of meaningful use?
Well, not beyond the example. Well, in my submission, not beyond the examples I've tried to give from the case law. There's not a. I'm not aware of a case that either side have put before you that explores that any further.
They haven't really provided any definition. They've said when it is meaningful use and when it isn't, but it hasn't come up. None of the authorities has come up with a formula by which one must test the application of meaningful use.
Well, there's nothing I can point to
that
explores that in any detail. Can I come
to before you leave 113, yes. Can I just raise this with you? There is a difficulty in categorising cleanly these various things, illustrated by that paragraph where you might have submitted that the Court of Appeal had in fact said it was a de facto deprivation, yes. And they say that they were treating it as a control. Isn't it also compounded by the fact that there are cases of control where compensation is going to be required, and cases you submit of deprivation where exceptionally it isn't? So is this really a requirement of the Strasbourg jurisprudence to categorise in this way, or is that simply an indicator of the severity of the interference?
Well, it's clear from the Strasbourg authorities we've looked at, and there are plenty of other examples, that the court in Strasbourg does seem to think it's important to begin its analysis by deciding which rule are we under, deprivation or control of use. And one of the points that I think is relevant to the point your ladyship's just made to me is that in some cases, and my learned friend has referred to them in his written case, the court has said it's really too difficult to decide whether this is a control of use or a deprivation. We just can't decide. There's, I think, a particular example of there's an Italian case in the bundle about the sale of a painting and restrictions imposed by the state on sale. And the court said it was so complex it couldn't decide whether it was deprivation or control of use. And in those cases, they have fallen back on this third category, which is the one that arises from the first sentence of the first paragraph, i.e. an interference with property. And they've assessed those cases under that rule rather than either deprivation or control of use. Now, the question is, what's the rule on compensation in that third category of case? And the answer is given by David Anderson in his article, the one we looked at in volume 4, which is it's such a small and amorphous category, these unclassified cases, that you can't say one way or another what the rule is. There isn't a rule one way or the other about whether compensation is generally required. But all of that said, what's quite clear is in the vast majority of cases, the Strasbourg court has started with that distinction and has put the case either in deprivation or in control of use. It has very rarely thrown up its hands and said we can't decide which one it's in and therefore we'll deal with it under interference. But I do accept all the points your ladyship made to me about the fact that obviously we're saying there's a general rule under control of use, no compensation, but must recognise, as the case law shows us, that it can be required. And alternatively, we also submit that deprivation itself doesn't always require compensation, as is supported by some other case law. So
What's the best example of compensation being required in a control case?
Well, I'm not sure.
Well, there might not be such.
No.
It might be a case in which they said it was a fair balance, taking into account the fact
Yes.
that compensation was paid,
Yes, or there was not a fair balance.
despite the fact that wasn't.
Yes.
But there is there any case in which they said no fair balance because no compensation?
On a control of use.
Yeah.
Well, apart from.
Well, Mr. Hockman may have one. I mean,
apart
it's
from-
more in his interest than yours.
I'm not in the Court of Appeal, but
Apart from Papa Michaelopoulos.
our case, but apart from that, I'm not sure
Yeah.
that there is. I'm not sure that there is.
And the intermediate category, or the third category, which you say is very narrow, you say that this case doesn't fall within it.
Doesn't fall within.
What is it that keeps it out of it?
Well, I mean, I will come to my submissions on why it's a control of use, but I mean, effectively, I say this is imposing conditions on a licence is a classic control of use case. And in addition, I make the point, which I've probably already made, but I'll come back to, that the test for this falling out of control of use, which it naturally sits into deprivation, would be whether there's an extinguishment of all meaningful use. And I say that test's not met.
Are you going to show sporong or not?
I wasn't going to show you.
Because that was one of the sort of first.
That was one of the first cases where, well, it's the first case, I think, where the court referred to the concept of a de facto deprivation. But the case, in the end, wasn't analysed as being a deprivation. If you remember, there were two restrictions there. One was an expropriation permit, which was the first stage in compulsory purchase, which effectively made the title precarious and which the government allowed to sit in place for many, many years. And on the other, there was a prohibition order which stopped them building on their land. Now, the prohibition order was said to be a control of use. But the expropriation permit, the court said, didn't easily fall within control of use or deprivation.
There was sort of expropriation permit which blighted the land.
Yes, it was effectively a blight.
So that's why it was on a special
Yes.
case. Yeah.
Yes.
Okay.
So can I come to the final of the English cases that I want to look at, which is key to our case, which is Trailer and Marina. So that's in the same authorities bundle too, at tab 15, and it's electronic bundle 1248. And in terms of the facts, if we could go to paragraph 8, electronic bundle 1252. The case concerned a canal, a Leven canal. It's described in paragraph 7, and you'll see in paragraph 8, the company in 71 purchased the freehold of the canal, including its banks, and the directors of the company intended, and indeed still wish, to restore the connection between the Leven Canal and the River Hull by repairing a lock, which is currently disused, to open the river to craft so that commercial fishing could resume, and to make the canal available to recreational anglers. And then the site is designated as a site of special scientific interest, that's paragraph 9. But over onto paragraph 10 and 11 on EB 1253, 1252 in the hard copy. Paragraph 10, the company first of all entered into management agreements, the effect of which was they were paid money by Natural England to restrict their activities on the canal. But in January of 2001, the 2000 Act came into force amending the provisions on triple SIs. And as a result, the second line, English Nature indicated to the company that the notification was absolute. It would not give consent to any works or leisure activities on the canal. And it further stated that the effect of the amendments would have was that they would not enter into any new management agreement and would not provide for a payment of compensation to the company for the effect of the notification, and in particular for inability to carry on activities on the canal, whether by way of compensation for a reduction in value or loss of profit. So this is a case where obviously previously they were being paid not to carry out harmful activities, and with the introduction of the 2000 Act, the view English Nature took was they would not pay people not to carry out harmful activities to a protected site. And the question was whether that was a breach of Article 1, Protocol 1. And at paragraph 15 and 16, page 1254 in the electronic bundle, 1253 in the hard copy, 15 and 16, you'll see the company's contention is the amendments to the Act, as affected, was at least in some cases incompatible with Article 1. This contention is based on the proposition that the consequence of the amendments affected often very curtailed, often very severely, the use which owners of SSIs could make of their land, and consequently reduced often substantially, indeed sometimes to the point of extinction, the profit-earning capacity and hence the market value of their land, without according any compensation for such a reduction. And at 16, it appears to us self-evident the consequence of the amendments by the Act would be to curtail, sometimes severely, the uses to which a SSI could be put for the foreseeable future, and this would have a detrimental, in some cases a severely detrimental effect on the profits which could be made from activities on the land concerned, and consequently on the market value of the land. And on the basis of the evidence provided, we are prepared to accept without deciding that it may well be that the uses to which the land in the present case, namely the canal, can be put, have been substantially curtailed for the foreseeable future, and this has had a substantial effect on the profit-earning capacity and hence the market value of the canal.
Was this a challenge to the legislation itself, or a challenge to the decisions made under it?
It was a challenge to the legislation itself.
That's what I thought.
It was.
Yes.
And Molly, that's the Court of Appeal in saying that this case didn't assist us, effectively said that that's why it doesn't assist us, because it's more about the legislation as a whole rather than looking at an individual decision. But I do rely on the case of setting out the relevant principles that are applicable also in this case on an individual decision, particularly around environmental protection and how it fits with Article 1, Protocol 1. And indeed, the point my ladyship raises comes out from, if you look at paragraphs 18 and 19, you'll see it says the first argument, this is of the government, is that the relevant provisions of the 81 Act and the 2000 Act are concerned with the control of use of land rather than expropriation of land for a publicly beneficial purpose. And the ultimate nature of the company's complaint is the Act as amended does not provide for any compensation for the control of use and consequent loss of profit-earning capacity and diminution in value of a SSI. It said the company's case must fail because Article 1 of the first protocol, as interpreted and applied by the European Court, does not require any compensation to be accorded in such circumstances. So that first argument, which is dealt with by the court, is, I say, obviously relevant to our case. But then you'll see there's also, and this is where there is a difference, the second argument that was made, and the court does also deal with that, is that nonetheless there were some particular features of this scheme which might allow, in the most extreme case, for a way out of those extreme consequences, i.e. by forcing English nature to grant consent or potentially even requiring them to pay compensation. But the court did rule on the first point about is this required as a matter of principle when one's dealing with environmental issues. If we then go forward in the judgment to paragraph 41 on page 1258 in the electronic bundle, you'll see there's a heading Article 1, and then 41, Mr. Howell, that's for the government and English nature. Mr. Howell's primary argument is that while legislation which has no provision for compensation will normally infringe Article 1 if it has the consequence of depriving a person of property, there will be no such infringement if the legislation results in the control of use of property, even if that control results in substantial financial losses. And then 42, no doubt that if you are depriving without compensation, that will normally infringe the article. And then 45, having set out some observations from James in the UK, those observations were concerned with deprivation of ownership of property, whereas the present case is concerned with the control of use of property. And in such cases, as Lord Hoffman made clear in Alconbury, Article 1 does not, at least normally, give rise to a right to compensation. And then you'll see there's a quotation from what was said by Lord Hoffman in Alconbury. Thus, under the first paragraph, property may be taken by the state on payment of compensation in the public interest so requires. And under the second paragraph, the use of property may be restricted without compensation on similar grounds. So an endorsement by Lord Hoffman in Alconbury of the general rule that I say is applicable, control of use not requiring compensation. And then 46, having set out some more detail from Lord Hoffman's speech, if Article 1 of the first protocol required the provision of compensation in legislation which restricted the use of property, the results would be very far-reaching indeed. The financial consequences of introducing laws concerned with town and country planning, listed and historic buildings, health and safety at work, and hygiene, to take some obvious examples, would be such as severely to cripple the legislator's freedom to introduce such socially beneficial legislation. Now, not surprisingly, I say that is material here, because regulators like the agency are required to take action in order to protect environmental assets and interests, particularly those protected by European Union law. And if the requirement of Article 1, Protocol 1 is that when we take such action, normally we are required to pay compensation, that would obviously have very severe consequences on the ability to act in terms of the budget. To say,
But I mean, in the planning law, as I recall, normally planning restrictions don't attract compensation, even if they severely restrict what you're doing. But if they deprive you of reasonably beneficial use, then you're given a remedy of being able to force the authority to acquire it.
yes, you can serve a purchase notice.
Yes.
Yes. So if you're refused planning permission and that affects your land, the value of your land, even severely, no compensation. But if it meets that very strict test in the Act about depriving you of any beneficial use of the land, you can serve a purchase notice and require the authority to buy the land from you. It's not very often used provision, but it does exist.
Well, of course, there's then a question about what your compensation is, and
Yes.
there may be assumptions made about that. But I mean, here, you see, is one looking at the effect of the legislation generally, as one was in this case, or is one also looking at the effect on a particular person? Because part of the point here is that Mr. Mott is affected in a way none of the other people are. And so one could see that there might be a case of saying that where a particular person is deprived of his livelihood by conduct, then that might involve a breach when the legislation doesn't.
Well, obviously, I mean, it is. We have to accept it is relevant to consider the position of.
But I wonder if it is, because I mean, the cases you were looked at, we saw a number of cases where some people were put out of business, others weren't. But the European Court didn't seem to make a distinction between them.
Well, the reason it didn't make a distinction was because it took the view that notwithstanding the very severe effects on those individuals, it still amounted to a control of use, and therefore, ordinarily, you don't have to pay compensation.
But it didn't seem to take into account the fact that in some cases
That is true.
the effects are
That's true.
more severe than others.
That is true.
And are you saying it's irrelevant here too, that Mr. Mott is much more severely affected?
I'm not saying it's irrelevant to
Why not?
But well, in terms of the action that we took, we took action directly to give effect to European law under the Habitats Regulation Assessment. And in that assessment, I do say it was irrelevant what the impact was on Mr. Mott, because we were not looking at the economic
No,
consequences.
I understand that, but in deciding whether there's a breach of Mr. Mott's rights under the convention, why is it not
Well,
relevant?
the reason it must be relevant to consider it is because the test that the courts have laid down is whether the effect, in deciding whether this is control of use or not, is does it extinguish any meaningful use?
Yes, but I'm coming on to the case where it's a control and where we're looking to see whether it's the exceptional case where compensation is justified. And I'm just wondering, I don't know what the answer is, whether or not it's relevant to look at the particular effects on this particular person's business, which are quite different from anyone else's.
Yes. Because, well, there is a stream in the case law, which I don't think we've picked up here. I think it is coming, actually, possibly in this case, about individual and excessive burden. So the European Court asked the question whether the application of this measure has had an individual and excessive burden on the individual. And if it does that, then obviously that has an effect on the analysis in terms of whether...
That's coming up in this.
I think it is, although I'll have to check. If not, I'll have to come back to it. But certainly in some of the cases, the way it's put is a fair balance is not struck if you take the view that an individual suffered an excessive burden. Now, one has to weigh that against, of course, the general purpose for why you're doing what you're doing and what the consequences would be of requiring compensation to be paid.
Well, obviously, if they had contemplated allowing a larger number of fish to be caught. They could then have contemplated apportioning those licenses, those limits, in accordance with the number of pieces of equipment butchers that the individual fisherman had.
Yes.
And that might, so as to avoid this individual
Yes.
and excessive burden depriving somebody of their livelihood. But on the other hand, as they've got such a small number of licenses, such a small number of fish, that wouldn't have made much difference to Mr. Mott.
I don't think Mr. Mott would say it would make any difference, because if you recall, we were looking at a maximum of 90 fish for butchers.
That's right.
Even if we'd given him all of them, I think his arguments before this court would probably be almost exactly the same.
That was the point I was making.
Yes. And similarly, my lady, as you'll know, there were other fishing licenses also caught, but as you say, even the number of those was not particularly high. I think the total number was 221, which, even if we'd given all of those to Mr. Mott, he would say, well, that's more than half the fish he caught previously. And of course, if we did that, it would mean that a number of other people who'd had licenses for many years would have effectively have lost any entitlement to fish. So that is the context, my lady, I agree, in which the question arises about the individual excessive burden here. Taking into account the fact that, of course, the Court of Appeal found that the overall restriction that we came to was rationally based and justified.
But I'd like, if we were coming to it, to see where that concept of individual and excessive burden comes
Yes, I'll
from.
try. If it's not in here, we will find it. We'll come to it.
Can I just ask you
Yes.
a question? You said you have to have regard to the purpose that you're doing this. Are you allowed to look at the purpose more widely, so that your purpose is to regenerate salmon stocks, and you will then regulate not only the butcher fishermen, but the other fishermen as well? One category of those fishermen, if it extinguishes their livelihood, will be in with a chance of having compensation. Another category of fishermen for whom it extinguishes their livelihood, on your argument, has no chance of compensation.
Yes, I think this, in my submission, that goes to the difficulties of what happens when you start to open up compensation in relation to a general environmental measure like this. It becomes, both in terms of dividing up the licenses, but also who might get compensation or not, potentially it is invidious. And that's why my primary submission is that there is no requirement in Article 1, Protocol 1 for a control of use for there to be any compensation where environmental interests, particularly very important ones, are in play. So otherwise one does get into an invidious situation, as your ladyship, I think, puts to me. In relation to we were looking at, I think, at 46. 47 refers to Sporong, and also you'll see just below the quotation, only case in which the European Court found such circumstances, which is de facto expropriation, was the Greek military case. And then over the page, paragraph 52, the reasoning of the court in the two cases referred to above appears to us to establish that when considering whether legislation which controls the use of property in the public interest infringes Article 1, a fair balance has to be struck between the general public interest and individual rights, which is tantamount to a requirement of proportionality. In appraising this, the court must accord to the legislature the measure of judgment discussed in the various cases I referred to. And then on to paragraph 56, 1261 in the electronic bundle, 12. You'll see 56 as reference to Banner and Sweden, which we've looked at on the as a rule, which is what's emphasised there, not as a rule require compensation. And at 58, the right analysis seems to be that provided the state could properly take the view that the benefit to the community outweighs the detriment to the individual, a fair balance will be struck without any requirement to compensate the individual. Should this not be the case, compensation in some appropriate form may serve to redress the balance. And then 60, page 1261, 1262, I think, in the electronic bundle, the general aim of the 2000 Act, and in particular of the transitional provisions, namely protect, preserve flora, fauna, and geological and physiogeographical features are of special interest is plainly a defensible, indeed a laudable objective. As we've said, it's one that can fairly be said to be in the public interest and in the general interest of the community. And then 61, as to the genesis of the amendments affected by the 2000 Act, the position is as follows. The legislation was preceded in September 1998 by a consultation paper, SSI, Better Protection and Management, which contained the government's preliminary suggestions, which at least in broad terms are ultimately reflected in the amendments affected by the Act. In particular, the view was expressed that compensating landowners for agreeing not to carry out damaging operations was inappropriate because resources should be devoted to the encouragement of conservation. Having received responses, the government published its proposals in August 1999 for legislation in a further paper, which was referred to. In somewhat less tentative and detailed terms, this repeated the government's preliminary suggestions and in particular repeated it was not prepared to pay out public money simply to dissuade operations which could destroy or damage SSIs on the basis that such money should be devoted to ensuring that conservation objectives were achieved. And I obviously rely on that. I say that's an important passage in terms of the case that I make, that as a matter of principle under Article 1, Protocol 1, it's not right for the state to have to pay people, to be required by Article 1 Protocol to pay people not to do things that damage protected sites. Here, SSIs in Taylor Marina, but even more so, European sites, which are of European importance, not just domestic importance. And so that's a passage that we place particular reliance on in terms of, I think, what was my fifth proposition about whether Article...
Yes.
And then finally on this case, conscious of the time, paragraph 65, you'll see it says, we accept, of course, the consequence of the amendments have been to diminish, sometimes substantially, the scope of the uses, accordingly to reduce, sometimes substantially, the income. It can fairly be said in these circumstances the public benefit enjoyed as a result of the amendments will, in the absence of any compensation provisions, have been at the expense of the owners and occupiers of SSIs. However, given the purpose and genesis of the legislation and the jurisprudence of the European Court, that cannot of itself justify an argument that there's been an infringement of the rights of the owner of SSI whose value has been substantially diminished as a result. And then 67 and 68, further argument about the extent of the harm caused. And you'll see at 68, in the present, Mr. Raby has not sought to persuade us the restriction placed by notification of the company's case falls into either category. In the present case, there's no question of the company being excluded from using the canal. Indeed, there's nothing to prevent it from exploiting the canal, albeit to a significantly more limited extent. But of course, it was a very significantly more limited extent because the whole plan for them to reopen it for commercial fishing and for other recreational activities was prohibited and not subject to compensation. And then the court deals in 69 to 71 with other exceptional provisions that existed in the legislation that could allow you to deal with a very extreme case under that legislation. So that's Trailer and Marina, which we rely on. Can I then turn, in conclusion, to make what I hope will be some short submissions now about what we say are the key issues and how they apply to this case. So the first issue is whether we are dealing with a control of use or a de facto deprivation. And I say for 4 reasons this is a control of use case. First of all, the nature of the measure clearly fits within the classification a control of use. A condition on a licence is a classic example of a control of use. And to treat it as a control of use fits, I say, with a number of the domestic and Strasbourg authorities that I've referred you to. These are conditions imposed on a licence which regulate the use of possessions. So that's the first submission. Secondly, the conditions imposed do not, and this is of course a relevant factor, not the only one, they don't formally deprive Mr. Mott of his lease, nor do they add any further restrictions to his ability to sell or dispose of it beyond those already contained in the lease. That's another relevant factor that the court has referred to. Thirdly, we recognise, as we must, that the limitations placed on Mr. Mott by these conditions have had a serious effect on him. But, as per the Posty case and the other cases I've shown you, conditions did not completely extinguish his right to fish. They did not remove all meaningful or beneficial use of the lease. And of course, I've shown you some cases where businesses have been completely put out of business, but the measure's still being regarded as a control of use and not requiring compensation. But in terms of what use can be put by Mr. Mott of the lease, can I just make these brief points on this, which is my sort of further points to my third submission. But first of all, you'll have seen government policy back to 1996 was to prevent the fishing of predominantly mixed stock fisheries, like the Severn Estuary, to phase them out. So that's what the government policy is. But the agency has not gone that far in this case. And you'll have seen there was a recognition of the heritage value of poocher fishing in the Habitats Regulation Assessment. So we have sought to allow such fishing to continue, albeit at a much reduced rate. We've not sought to completely remove it, as is the government thrust of government policy. Secondly, under the catch limits imposed, Mr. Mott remains able to take 30 fish in the first year and a slightly smaller number in the further years for his personal use, or no doubt to sell individual items of fish if he wants to, 30 fish, but I think he says on his balance £100 a fish. But there are also, as I suggested, possible alternatives which have been encouraged by the agency. There's only one reference I can take you to on that, and that's in Bundle 2, page 337, and let me just get the electronic reference will be EB 453.
What is this document?
This is the document that the Court of Appeal referred to when I showed you the Court of Appeal's conclusions. They referred to the net limitation orders technical case as providing the background.
This is the
technical case. So this is the document that the Court of Appeal extensively quote from. And at EB 453, 452, if you're looking at the written version, the top of the page, above 3.6, it says it's a paragraph that starts, a small regulated fishery will help maintain the heritage value of the methods used in the future assessment, etc. Then it says, although the HI fishery was not part of this NLO consultation, if you remember, historic installations can't be restricted by net limitation orders. So although there's reference to historic installations here, they're not.
I haven't got, which page are we on?
Sorry, page
453.
It's 453 in the electronic bundle.
Yeah, okay.
You'll see
Yeah.
it says the
Oh,
catch.
yes, I see the top, yes,
So
sorry.
although the HI fishery was not part of the consultation, the catch condition imposed on them in the last 3 years, so that's 2012, 2013, 2014, means that the ranks that choose to operate will primarily be doing so as a heritage initiative. We hope and anticipate that they will fish using traditionally shaped poochers and techniques. HI fisheries lend themselves far more to tourist activities, and it's hoped that this side of the fishery will remain to benefit the local economy in the future. And the reality is that, as the judge found below, and I'll take you to that now, if we go in Core Bundle 1 to the judgment of the judge below. So it's electronic bundle, I think 173. Yes, electronic bundle 173. And in the hard copy bundle, it's volume 1, appendix E, and it's at the top right-hand corner, EB, page number 172 in the hard copy, and it's 173 in the electronic.
What are you drawing our
Oh,
attention?
96. You'll see 96, the judge says, the second line, the claimant's right is largely, but not entirely extinguished. It could be exploited and would presumably have some small value if sold for leisure interest rather than commercial use. I don't rely on the sale point, but I rely on the fact that there's a recognition that it could continue to be exploited. And then he adds, the judge, later on, sorry, just give me a moment. Yes, if you go back to paragraph 87 on page 169 or 170 in the electronic bundle, Mr. Lewis submits that the measures concerned could only be considered a deprivation if the limit set so low that the right to fish is not worth using at all. This was not the case here, since the level had been set at the average level of catch, in fact achieved by at least one licence holder. So it must be the case that at least one person has found it worthwhile to exercise the right to fish at that level. So the levels that have been set reflect the previous lowest licence applications that were received, and therefore there are people who are making use of putcher fisheries for the limits that are set. Now, for all those reasons, my third submission under this first heading is that not all beneficial or meaningful use has been excluded. I accept it's a significant restriction, but it's not all meaningful use. And then finally, my fourth submission on this is these are annual restrictions. They're not once and for all. And if, as is anticipated, the controls have the effect of, in the medium to long term, improving the stock of salmon, then in the medium to longer term, the number of fish that can be caught can be increased. These are not a one-off act like a deprivation. And then, so that's the first subject matter I needed to deal with, which is why we say control of use, not deprivation. If it is a control of use, then can I make these brief submissions about why it strikes a fair balance, absent compensation? So first of all...
You've got 5 minutes left.
I know, 5 minutes. I'm going to do it. First of all, no dispute that the catch limit conditions pursue a legitimate aim. They are protecting European sites, qualifying features that are at risk. So that is, as we would say, using the language in trailer and marina, not just a legitimate aim, but a laudable aim. Secondly, this stock management ultimately is also of benefit to Mr. Mott and the other fishermen. Because if, of course, the salmon are overfished and the stocks collapse, then that benefits no one at all. Thirdly, returning to the environmental reasons for catch limits, we say it's a key feature of this case that the catch limits, the conditions that were imposed here, were imposed because we took the view that it was required in order to protect the environment, and that was a view agreed with by the relevant nature conservation bodies. Fourthly, the decision needs to be seen in the wider context of a long-standing government policy to seek to end mixed stock fishing. And our view, rational view, was that this was such a fishery. Now, we've not sought to end all such fishing. We have sought to allow it to give effect to the heritage value of such fishing, but only at a sustainable level. And of course, I ask you to note that if you remember when I showed you the Court of Appeal's judgment, the government policy on ending mixed stock fisheries goes back to 96, so before Mr. Mott took his most recent lease. And there were two studies, which are referred to by the Court of Appeal, Swain, and I've forgotten the name of the other one, which were saying in the 1990s that this estuary was a mixed stock fishery. So that is also, we say, relevant to the fair balance. Fifthly, because it is a control of use case, there's no presumption or rule in favour of compensation. See Boehner and Trailer and Marina and the other cases I've relied on. Sixthly, the question the Court of Appeal posed in Trailer was whether the state could properly take the view that the benefit to the community of a measure outweighs the detriment to the individual. And we say that is the position here. A fair balance has been struck, given the importance of the environmental considerations and the harm that could be done by requiring compensation. And we take the point further because we take the point further by saying that the government should not have to pay compensation to individuals not to cause damage to European sites. And obviously we rely on Trailer and Marina, But can I also point out, we also rely on the polluter pays principle, and that's why I put in that recent Privy Council case that two members of the court I know will be familiar with. And the reason I put it in is a very simple point. I'm not saying that Mr. Mott is a polluter in the sense of putting pollution into the river, but what the Privy Council held there rightly was the polluter pay principle didn't just cover pollution, it also covered the causing of environmental damage in any other way, and it included not just curing or remedying pollution, but the cost of preventing pollution. Now here, I'm not saying Mr. Mott's a polluter, as in the strict sense of that word, but he is doing something that is causing damage, along with other people, to a European site. And in my submission, the polluter pays principle supports the view that the person who should pay for that is not the state, but it's the person who's carrying out the damaging activity.
And you're really relying, in effect, just on the short statement at the beginning of my judgment, which talks about what the polluter pays principle is.
Current definitions. And so, well, for example, the two examples, it's really, in paragraph 2, the Article 8 that you've quoted from the United Nations Assembly, talking about pollution and other environmental disruptions and degradation. And you'll remember we're talking about a European site that's getting into a situation of unfair...
Yes, it's right to emphasise that that's very much a draft promoted by President Macron, not just adopted in any form by the...
No, and then on the same paragraph, paragraph 393, you'll see understood to go further than just curing pollution, but also to stop...
Well, that was based on the Advocate General.
That was on the Advocate. Now, we say all of that's relevant in terms of the fair balance, and in this situation, if it's a control of use, the fair balance is struck. I know I'm out of time, so the very last point, which I'll make very briefly, in relation to the third issue, if this is a deprivation, why do I say it's an exceptional set of circumstances? Well, the arguments are broadly the same.
You say all the same things.
They're the same things, but I obviously particularly focus on a harm to a European site as being the key thing that makes this exceptional. You're harming interests that are recognised as the most important in nature conservation terms. And well, can I just say, Lord Colmouth asked about the individual and excessive burden and the source of that. It actually comes from the Sporon case, which you've got in volume 4, tab 42, and it's paragraph 73 of the court's judgment, EB 2072.
33.
73,
73,
paragraph 73, where it talks about whether the estate bore an individual and excessive burden which could have been rendered legitimate, and they say only if one of two things happened. Either you reduce the time limits that the expropriation permits were in force, or there was ability to claim compensation. So even where there was an individual and excessive burden held to exist, compensation wasn't the only answer there. They could have done it by other measures, like reducing the time limit that it applied. But that's the source of that phrase, which does get picked up in other cases.
But it does suggest that where you have an individual and excessive burden, one should recognise it in some way.
Yes, in some way. If you consider the burden to be excessive. But of course, in deciding whether it's excessive, you have to have regard to how that's judged against the objectives of the measure that you're pursuing. So, my ladies, my lords, unless I can assist you further, those are my submissions.
No, thank you very much indeed, Mr. Parisi. Mr. Lewis, do you follow? Well, the court will now adjourn, and we'll look forward to hearing from Mr. Hockman at 2 o'clock.